AB 1843, juvenile criminal history. You're seeing a lot of legislation here on the state level, and my next slides are talking about LA City banning the criminal history inquiries when you're hiring employees. So effective January 1st, 2017, we have this on a statewide level, prohibiting employers from asking or taking into consideration juvenile convictions. And here in Los Angeles, and I knew, like I said, I was debating whether to have this webinar this late in December. I thought everybody would be busy with holidays and everything, but I'm glad I waited. Sometimes the procrastination pays off. We had Los Angeles just last Friday the mayor signed into law that affects any employers operating in the city of Los Angeles. It's basically one of these ban-the-box laws. The law's Los Angeles Fair Chance Initiative for hiring. Basically applies to any employers with 10 employees or more, and prohibits employers from asking or looking into the criminal background of any employees until after a conditional offer has been made to the employee. It's a pretty drastic law for Los Angeles, employers here in Los Angeles. It's basically employers can't even search the internet on their own for criminal background history for the applicants, and I am recommending that employers need to revise their applications as soon as possible. I really like that the city gave us, less than 30 days notice that this law was coming into place, and you have to comply with this as of January 1st of 2017. It looks, though, that likely the city won't be imposing the fines until July of 2017, but the law is in place, and I do recommend that employers review and revise their applications as soon as possible. Let me see other considerations for the Los Angeles City ban-the-box legislation here. It gets really complicated if you do make a conditional offer to the employee and you tell the employee the conditional offer can only be based on the background check. The background check does come up with some criminal history, and you're going to deny the employee the job based on their criminal history. It requires a written notice to be provided to the employee setting out this assessment, and it's very detailed on what this assessment needs to look at. And I don't recommend employers doing this on their own, at least at first. There's some very specific factors that the employer needs to look at if you're going to deny somebody a job based on their criminal history here under this law. And then basically it requires written notice to the employee, and then 5 days for the employee to provide additional information, either correcting or clarifying the information that the employer found. And then if the employee is still not hired at the end of that, the employer must actually provide the employee with that written assessment that they did, setting out those factors. So it's a very detailed law, and I think it was a bit of a sleeper issue for a lot of employers operating here in the city of Los Angeles. Some other requirements showing how drastic this law is. Basically, any kind of solicitations or advertisements, the employer needs to set out that they will consider qualified applicants consistent with the requirements of the LA City law. They also have to post another notice informing applicants of the law at the place where the applicants are going to be coming in applying for the job, and also have to retain applications and related information for 3 years. So pretty drastic requirements going forward for LA City employers.